Good afternoon. This is Sean Golding with Golding & Golding here to revisit the issue of Malta pension plan / retirement schemes, how to get into compliance, what you should do, things of that nature. Over the past several years, our firm has written several articles on the Malta pension plan. We have other presentations on this as well. So the purpose of this presentation is not really to go into whether the retirement scheme is legal or not. It's more about what do you do now, right? Recently, there was a coordinated effort between the criminal and civil factions of the U.S. government in order to pursue taxpayers who have these Malta pension plans. Now, taking a step back, okay, this is not for the typical person who might have worked in the UK and then they have their own pension plan and then they move their pension plan legitimately into like a QROPS in Malta and then maybe they became U.S. persons down the line. That's not what this is, okay? This is for taxpayers who may have, been doing some tax planning, some estate planning. They have some wealth, high income earners, and they speak with certain tax professionals, maybe even promoters who sell them on this idea of the Malta retirement scheme. And what the concept is that it's sort of kind of like a Roth IRA. So what would happen is taxpayers would contribute post-tax dollars into the Malta retirement plans. Now, with a Roth, for example, there's a maximum amount you can contribute depending on what you earn and et cetera, et cetera. These weren't like that, right? So taxpayers would take millions upon millions of dollars of cash, assets with gain that hasn't been realized yet. And then there's a way you can stagger the distributions depending on your age and the amount so that at the end of the day, you can receive some of these funds tax-free or reduced tax rate, but primarily tax-free. And the IRS doesn't like this, right? So now they have been going after taxpayers with summons and John Doe summons and all these types of things. So what do you do, right? There's no knowing yet whether there's really any meat to the argument that it's going to be criminal, right? There was a glitch in the matrix of the treaty before the CAA came out, competent authority arrangement. And so for taxpayers who are out of compliance with the Malta pension plan, we'll just call it that, but again, we're not talking about legitimate employment pension, okay? There are options that they can use to get into compliance. So let's talk about that for a bit. If you knew that it was improper or you thought that you were willfully avoiding tax, then you would do the voluntary disclosure program, VDP. There used to be a specific offshoot called OVDP, Offshore Voluntary Disclosure Program. I think it started around 08 or 09 and ended in around 2018. But the traditional voluntary disclosure program has been around forever. And so OVDP merged back into VDP. So when you see VDP, that essentially means offshore and domestic. And, you're going to pay a gargantuan size penalty, especially depending on the size of your undisclosed assets, the amount of income that you have, et cetera, et cetera. But, you work your way through the process, and 99% of the time you'll avoid criminal prosecution. In fact, we've never had anyone criminally prosecuted who did VDP. We've done thousands of offshore disclosures between willful and non-willful, and we have several other articles and presentations on that. But you do this, you get a closing letter in 906, and you're pretty much done. But it's costly. Now, if at the time that you were doing the Malta pension plan, you thought, well, this is totally legitimate because according to what some tax professionals have told me or promoters or whatnot, based on the treaty, and there was a problem with the treaty, which is why the CAA had to come out. I believe it was 2021, but because there was a loophole. Loopholes are not illegal, okay? So if you thought that what you were doing was totally kosher, and you had attorneys or CPAs or other tax professionals telling you it's kosher, then, maybe you're not willful and then you're non-willful. Then a whole world opens up of the different compliance options, okay? You might want to consider the streamlined procedures. If you qualify as a foreign resident under streamlined foreign, there's no penalty. If you qualify for streamlined domestic, there's a 5% penalty, which still blows, right? But it's a lot less than a 50% penalty, or even worse if you're audited and then hit with willfulness penalties. Depending on whether you actually had received any income yet, things like that, you may qualify for delinquency procedures, depending on what the value of your pension was and which delinquency program the delinquent FBAR submission procedures, which still pretty much offer a penalty waiver. Alternatively, there's DIIRSP, delinquent international information return submission procedures, where since November 2020, they don't offer the automatic waiver anymore. And then some taxpayers may qualify for reasonable cause. Under reasonable cause, you're basically taking the position, hey, I relied on this tax professional. There's various factors you have to prove. And if you can prove that reliance is that you acted with reasonable cause and not willful neglect, then you can avoid penalties altogether. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter and something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.